Good morning and welcome to today's Sustainability Series Part 3, Greenwashing, Why This Should Keep You Up at Night. I am Theresa Bevilacqua. I'm the co-chair of the Commercial Litigation Practice Group here in Dorsey's Minneapolis office. And with me today is Simpser from our Regulatory Affairs Group. And we're here to tell you about all the new nightmares you should have related to your product or corporate aspirational goal claims that you make regarding sustainability, carbon offsets, and carbon credits. Before we get too far into the presentation, a few housekeeping notes for you. Please do sign in on the attendance form provided to you in the email containing your materials for today. They are all available from download, also from events@dorsey.com if you do not have the email at your fingertips. And please remember to return your completed attendance form so that we can give you the CLE credit. We will also put this information in the webinar chat for you. We will be applying to CLE in the jurisdictions listed on the invitation and on the screen right now. And we can see where the CLE is expected to receive credit. Unfortunately, we have a lot of ground to cover today and you all are not here in person with us. So we will not have the chat function up and running during the presentation. But we do encourage you to reach out to your trusted Dorsey contact or to Zev or I individually if you have any further questions or comments on today's materials. After the program, we will also be sending out a survey and we would really appreciate your feedback. So let's talk about what we hope to accomplish today. We have two primary goals. We want to address the current trends as we see them surrounding sustainability claims. And that relates not just to the word sustainable, but other claims you might make regarding carbon credits, carbon offsets, net neutral, et cetera. And those relate to not only a product's label claims, but also corporate claims that are made by your communications departments and also your aspirational goals. And then we want to help you understand what the risks are involved when you make a claim, particularly on a product and its label regarding the product's sustainable nature or the inputs to the product, that the product is sustainably sourced or is coming from areas that are sustainably sourced. And we'll talk about the upstream and downstream risks for carbon products and also consumer-based litigation involving product claims for sustainable goods. And with that, I'm going to turn it over to Zev.
Thanks, Theresa. We'll start off by talking about some of the topics that came up in the second part of this series with respect to carbon products, because as entities are making more and more claims with respect to sustainability, net zero carbon emissions, and other things, ultimately, most of those claims are going to need to be backed by some kind of carbon product. If you can get your scope 1 emissions down to 0 and you can get your entire value chain to have scope 3 emissions down to 0, you should be giving this seminar. But until that time happens, it's likely to be that you are going to need to offset some of your emissions with carbon products. And because of that, we're seeing more and more in the marketplace the sale of carbon products to do that. You can be a net purchaser of those products because you are trying to offset unavoidable carbon emissions from your activities, or you can be a net seller. For example, if you are a small scale farmer, you could be actually selling carbon credits coming from your activities because that's part of your money-making ideas. With the carbon products, you're going to have upstream claims and downstream claims. What that essentially is going to mean is that as you talk about your entity and itself, people upstream from you in the value chain are going to rely on those claims. And current guidance says that they should be able to. And so if they're relying on claims that are false or misleading, that can be problematic for you on that reliance issue. Similarly, you are going to look downstream for additional information to help you manage your items and also to purchase products potentially from downstream customers in your supply chain or value chain. And again, you may have claims against them from that perspective. The other thing is really about talking about veracity and quality of products. And what we're seeing with the carbon products, especially with forestry carbon credits now, is really some growing media attention about, do they really achieve the outcomes that they portend to? So moving on, we talked about the reliance, interest, and risk. That's really, I think, an important one for creators and purchasers and passers on of carbon products. And essentially, nobody can get out of that reliance risk. When you're reporting information up the value chain, for example, if you're a large CPG customer or CPG company, and you're reporting into your large retailers' systems, there are certain reliance interests that can be that you should be aware of, and that can be of concern. And what that really means is you have to have good data backing up what you're doing. Similarly, the quality of the carbon products you may be buying to make your offsets or your value chain or your inset claims is really going to be important. So when you're looking to purchase carbon products, risks regarding merchantability, risks regarding purpose, veracity of data are going to be risks that you're going to want to assess. Those risks are all overcomable so long as there's full disclosure. And so the theme of the last seminar was know what you're buying. And we're just continuing that over here. And Theresa is going to explain to you why that's going to be so important. To foreshadow what some of those things are is risks of lawsuits from green groups. And I think Theresa's bet more risk of lawsuits from enterprising plaintiffs' lawyers. And then also spreading liability, defraying risk, and using your carbon products to essentially bring in your entire value chain. So why does this matter? Well, what we are seeing in the industry, and I think the attendance numbers of this seminar really demonstrate, is there are increasing pressures with respect to sustainability, carbon goals, and that the marketplace is ultimately demanding that products have these things. And I mean, the list of entities that have made these pledges are incredibly long and growing longer. And just as importantly, large entities who are making these pledges are pushing these requirements down throughout their supply chain and value chain. And so even if you haven't made these requirements, your big customers may have. And so it's something you need to be aware of. And a lot of those marketplace pushes end up with eco-friendly, sustainably sourced, carbon neutral, carbon-free claims being made directly on packaging, being made as part of a sales pitch for product X or Y when you're doing a B2B transaction, and ensuring that these items are, the veracity of these claims can be sustained, and what that really means is going to be very, very important. There is, just as all fraud risk, labeling risk that comes with those things. You're also potentially making claims with parts of your value chain that you cannot control. So again, the veracity and the ability to substantiate these claims is really, really important. And we will also talk today about using third parties to certify that your products are sustainable. We believe that that trend is changing significantly now, but that used to be the NA Plus Ultra, a reputable, not profit, non-governmental organization to certify your product as sustainable, provides a lot of cover for your liability risks. But as Theresa will discuss, you'll see that that may be changing as well. So there are just inherent risks from entering this market, as we've discussed. I think the big one is that there are currently no real regulations around this. We're living on a fraud-based standard. There hasn't been any real definition outside of some compliance markets in California that we're aware of in the US, where you have a clear set of regulations that you can comply with. The SEC has started to toy with certain disclosure obligations, but those are disclosure obligations. And some other entities have looked at regulating certain of these sustainability products like the CFTC and carbon products. But with that said, all of this may be subject to change. You may put in an entire compliance regime, and regulations in a state or even, quite frankly, a locality may really upend that. But currently, all of this is judge-made law. And so you do this at your own risk.
And the types of risks, the title on the slide is for trends or labels in consumer goods as sustainable, but there are other risks attributable particularly to publicly traded companies or corporate disclosure statements or corporate claims made by your corporate communications department or whatever it might be on how green your company is. And we're seeing an uptick in those types of claims being filed, both from a securities fraud or a corporate fraud perspective, right? So if you've got a disclosure obligation and you need to make a disclosure under whatever the SEC has said its requirements are of the day, you're making those disclosures typically. But if you're going above and beyond that, which is the trend, and it's what we understand your internal management and leadership wants to do, right? They want to go above and beyond, and they want to say something affirmative about the sustainable practices and the carbon-free policies that you are adopting or what your goals are. Well, typically prospective and forward-looking statements are going to be covered by a safe harbor in your corporate disclosure claims. But whatever you are saying, it has to be accurate at the time, right? And we want to make sure that you understand the risk of saying too much and making too broad a claim and using non-specific language, because that's the language that's going to get you in trouble, both in a corporate disclosure context or a corporate aspirational goal context, but also in your product labeling claims. So we've seen a growing number of nationwide consumer class action claims against all types of consumer products, particularly ag-based, food-based products is sort of the case du jour, right? Because those are making fairly specific or sometimes too broad-based a claim about the inputs to the ingredients that are going into a prepackaged food product or something that you might buy on the shelf or a coffee that you might buy at Starbucks. And so we've seen first a wave of cases brought by environmental organizations such as Greenpeace or the Sierra Club. But now we're seeing much more consumer-based state law, deceptive trade practices, standard consumer fraud product labeling claims being brought as class actions in multiple jurisdictions. And then we also have the potential impairment for your long-term supplier relationships. And that's what Zeb was talking about earlier in terms of the upstream and downstream claims that you might be making for any given product within your portfolio. And what's the impairment if you are sourcing all of your milk from one particular dairy or one particular farm, and they are making claims about the hormones that are or are not being given to the cows in producing that milk? What is the long-term effect on that supplier relationship when you repeat those claims on your product label? So we'll get in now to the nitty-gritty on what these current case examples look like for claims being made against product manufacturers and ultimate retailers for sustainable goods. California and the Ninth Circuit does lead the market, unsurprisingly, because they have, I would say, the most fulsome state consumer product friendly laws. And they also have, a lot of state court and federal district court action with respect to greenwashing claims. We also see a number of claims on the coasts and in other typical plaintiff-friendly states for consumer class actions like Illinois. So the Northern District of Illinois, you'll see, has an uptick in these consumer-based class actions. All of these cases, unfortunately for companies like you all, are based on a reasonable consumer standard, right? So that means it's unfortunate because it's very difficult to get rid of these class actions at the early stage, at the motion to dismiss stage, because 99 times out of 100, what is reasonable to a consumer, or what a reasonable consumer would take from a product's label, is going to be a question of fact. We are also seeing generally that the broad labels like sustainably sourced or carbon neutral or eco-friendly create a much higher risk in the litigation, especially it decreases your chances of being able to dismiss one of these claims early in the litigation without spending a ton on discovery or motion practice, because those broad claims can't be substantiated the same way. It's very difficult to come and show third-party verification of something as amorphous as sustainably sourced. Although we also understand that there's a tension between what you can claim in the finite space on a product's label, and depending on the size of the packaging, you may run out of real estate very quickly. So we want to help you choose your words carefully and understand which words come with the highest risk. So now let's talk about the nightmare that is keeping you up at night on this reasonable consumer standard for product claims. We have some good news, we have some bad news, we have some ugly news. And we're going to start with the good news. And for all of these, we're going to start with what does the product actually say, and then how does the court interpret that product's label? So again, it's a reasonable consumer standard. What would a reasonable consumer draw from the claims made on the label? So the Moore versus Trader Joe's case, which went up to the Ninth Circuit after it was dismissed by the district court, and that dismissal was affirmed by the Ninth Circuit in 2021. The product's claim was 100% New Zealand Manuka honey. I don't know what that is. Zev and I agreed before we should go and test this product. It sounds pretty yummy, but the label was fairly specific, making a claim as to what the product was. And the district court made a finding that this label, 100% Manuka honey, was not misleading as a matter of law on a motion to dismiss, and found that a reasonable consumer would not share the plaintiff's unreasonable and fanciful interpretation of what 100% New Zealand Manuka honey meant. Meaning, even though it says it's 100% New Zealand honey, everybody would know it's not. Why? Why would a district court come to that conclusion as a matter of law? And what the court found is there are contextual cues and clues on the label that go beyond that short claim of 100% honey. And the reason is consumer familiarity with this product itself would tell someone that it's not 100% Manuka honey, that there are differences in the product, and those differences are driven by price, and common sense generally must be factored into the reasonable consumer analysis. And any reasonable consumer with common sense, reading everything else that was on this label, would quickly come to the conclusion that it's really not 100% New Zealand Manuka honey. There are other additives or other components that go into the honey. So it's a really great case to give us hope that maybe you can get out of a case early and have that case dismissed and have that dismissal affirmed. There's also hope in the Eighth Circuit for those of us who are within the Eighth Circuit. And that's the Song versus Champion Pet Food case that was decided in 2022. And again, the analysis at the district court and again at the Eighth Circuit focused on the label. Fresh regional ingredients. We focus on fresh ingredients from our region that are ranched, farmed, or fished by people we know and trust. And here, again, federal court, you have at least the Iqbal and Twombly standard of plausibility. And what is plausible for a claim of deceptive trade practices or product mislabeling claim? The district court and the Eighth Circuit affirmed that it's not plausible a reasonable consumer would interpret the fresh regional ingredients the same way that the plaintiff did in the complaint, meaning that the dog food was made only with ingredients that were fresh and reasonable. And again, there were other claims and other disclosures made on the packaging itself, which showed that there were some non-fresh items that had to be included in a prepackaged dog food that's sold on a shelf, not in a refrigerated section. So there were all of these other context clues that made the label sufficient and not misleading as a matter of law. Now we get into the bad news, right? And the first bad news is out of the Central District of California from 2021, and that's the Myers versus Starbucks et al. So this was a class action that looped in a number of corporate defendants, and it including M&M Mars Company, the Quaker Oats Company, and Starbucks. And these are all about claims related to hot chocolate, right? And where Starbucks was sourcing its hot chocolate, what product claims were being made on the labels or in the stores for Starbucks as well. So the district court dismissed Mars and it dismissed Quaker Oats from the lawsuit. And why? So it dismissed Mars because the label for Mars cocoa said it was traceable from the farms into our factory. And Mars could demonstrate through its good data that 24% of the cocoa it sourced was traceable. Now, I want to be very clear, the 24% might not fly if Mars had made a more specific or different claim about it. They didn't say a majority was traceable. They didn't say all of it was traceable. They didn't make a percentage claim. They just said the cocoa is traceable from the farms into our factory. And the court found that they could demonstrate 24% of it was traceable, where it was coming from, and that was sufficient and let Mars out. Quaker Oats was dismissed for a different reason. And they only claimed to support sustainability, and they listed the specific organization and could demonstrate financial contributions to that organization that was undertaking the specific sustainability efforts. And this was to replenish or replant cocoa farming practices. So because they could demonstrate through their corporate documentation and having that good data that Zev referred to, how they were actually supporting sustainability financially, they were also dismissed. Starbucks remained as a defendant and was not dismissed. The claim related to its hot chocolate was made with ethically sourced cocoa. Now, I don't know what ethically sourced cocoa is or means, and that is subject to a wide interpretation, and a reasonable consumer could invent lots of reasonable conclusions as to what ethically sourced cocoa is. And because it was so ill-defined, and because Starbucks didn't have some hard, good data to back up the claim, the plaintiff's complaint survives the motion to dismiss and lives on today. And now we get to the ugly. And this is the case that Zev and I have been watching for, about 2 years, and are still surprised that there's nothing that has really happened in more than a year. So this is the Marshall versus Red Lobster management case out of the Central District of California. It was filed in June of 2021. And the claim relates to what Red Lobster says in its menu. There's a QR code and there's a link, and it's, seafood is traceable, sustainable, responsible. If you want to know more, go to our website. And we source our seafood to the highest standards. And the claim is, well, that's false and misleading. And I shouldn't have to go to your website. I should be able to find out more instantaneously from your menu. In the complaint itself, the plaintiff cites to several articles about consumer undertaking of sustainability, as well as the existing FTC guidance. that warns companies from making broad, sustainable, eco-friendly, eco-conscious cases because they're subject to interpretation and because they're not specific and because they could easily be misleading. And that guidance was most recently updated in 2012, but it remains about 30 years old, completely inadequate and completely out of date in terms of any of your ability to rely on that guidance as a beacon for what you should or could disclose on a label. Red Lobster, for its part, moved to dismiss and said its specific promises were much more detailed than plaintiffs' subjective sustainability standards, and that its claims made both on its website and on its menu were within the guidance that currently exists. They made a motion to dismiss. It was argued in May 2022. I checked the docket again yesterday and this morning, and there is still no order on that motion to dismiss. What there is instead is a number of what we trial lawyers refer to as 28J letters. So the plaintiff's counsel submitted numerous supplemental authority. And it's that supplemental authority that really is the nightmare that we are trying to help you avoid. So they put in 4 or 5 or 6 different district court opinions that have been issued since the time the motion to dismiss was argued and today. And I'm going to talk about just a few of those. 2 of them relate to the grocery store Aldi. One is by an eco-friendly nonprofit organization called GMO Free USA versus Aldi, and that's 21 CV 0786 out of the District of Columbia Superior Court. And the claims all relate to the packaging of Aldi's in-house brand salmon, and whether it is sustainably sourced, sustainably caught, and a humane practice for capturing and then selling the salmon. The claims made on the package itself, there are 2. One says that it meets the standards of an independent third-party organization related to catching salmon and other seafood sustainably. And then the specific claim that the retailer places on the package is that it is sustainably sourced. And the nonprofit brought the claim. Aldi moved to dismiss, and the third-party verification, so the third-party organization that says, no, this is a sustainably sourced seafood product, moved to file an amicus brief supporting Aldi on the motion to dismiss. The district court in DC denied the motion to dismiss, saying the consumer had stated a plausible claim, but allowed the third-party verification and independent third-party certification company to file an amicus and to participate going forward as an amicus. In the Northern District of Illinois, the defendant and the same third-party certification organization were not so lucky. In that case, Rawson versus Aldi, which is 21 CV 2811. Again, the same product packaging claims, same third-party verification organization. The district court denied the motion to dismiss and denied the amicus status of the third-party organization at the motion to dismiss stage, left open the possibility that through discovery, maybe they would become a third party, or maybe on a motion for summary judgment, that organization could have amicus status, but that it was wholly inappropriate to allow them in at the motion to dismiss stage, because all we are talking about on a motion to dismiss is this a plausible claim under Iqbal and Twombly in the federal system? And has the plaintiff met the plausibility standard? It doesn't really matter, and the court didn't want to look beyond the 4 corners of the complaint or the product's label itself to what a third-party certification organization might say about its own standards, because that's not the subject of the complaint. The subject of the complaint is Aldi's claim on the packaging. Then there's also Spindle versus Gorton's, out of the United States District Court for the District of Massachusetts, case number 22-10-599. And again, the motion to dismiss, which relied on both third-party verification claims to sustainability and the company's own sustainability claims, was denied. And so we look at least in the seafood context, and for the Red Lobster case, it looks to be very difficult to get out on a motion to dismiss when your claim is sustainably sourced. What about other claims that don't relate to sustainability of seafood products, which I admit is a narrow niche? Well, there's still some ugly law out there as well. So the first one that we're going to talk about is United States versus Kohl's, and it's also Kohl's and Walmart. And this is out of the District of Columbia. And the FTC brought a claim against Kohl's and Walmart for false advertising and false product claims based on advertisements and product labels about the benefits of converting bamboo into rayon and other eco-friendly claims related to the textiles. Within 30 days of the claims being brought or being public, both companies settled for $5.5 million. So it tells you something about, number one, the discussions that were likely happening between the FTC and these two large retailers before the complaint is filed, and how quickly they resolved it. And the amount also tells you there's some teeth there, right? And it applies not just for agricultural or food products, but it applies to textiles and anything where you're making a claim about eco-friendliness and sustainability. We had another case out of the District of Maine on Norwegian salmon farming, again, claiming it's sustainably sourced. The case was filed, a motion to dismiss was filed, and before any argument was had on the motion to dismiss, a $1.3 million settlement. And that, I will tell you, is way less than a cost of defense. So it makes sense for the Norwegian salmon farming giant to come in with a class action settlement amount and have that paid out than defending one of these large scale consumer class actions. And the last one is Curtis v. 7-Eleven. So again, this is a retailer now, 7-Eleven, and they have an in-house brand of cups and plates that they market as recyclable. And just to be clear, these are not paper products. They are either styrofoam, some other sort of petroleum or plastic-based products that the company was marketing as recyclable. And they moved to dismiss on the basis that the state laws allow them to make those claims as to the recyclable nature of the products. And that motion to dismiss was denied. And so it survives and lives on. So now that we've talked about all of the parade of horribles that can happen regarding the claims you might make against your or for your products, let's talk a little bit about how you can mount a great defense and have an antidote.
Thanks, Theresa. I think a lot of this is pretty straightforward, and to the extent you're a consumer product or a B2B product that sells things, it's pretty much business as usual. I think the real difference here is these concepts are complicated. These concepts are not ever core business. And so it makes it much harder for people to understand the details that ultimately underlie a lot of the potential for there to be claims, and also a lot of the potential for you to have a claim that you can substantiate. And so it becomes a real challenge. And especially as you get higher and higher level, I'm eco-friendly, I'm sustainable. We all like to throw those things around, but I think what we're seeing is that the law is not going to be very friendly to those kinds of even offhand claims. And it's unclear if, your vice president of sustainability or your chief sustainability officer is going out and giving a speech and there's a forward-looking statement, safe harbor statement, that may not be sufficient to protect you. And so it's really, really important that the issues related to what you are claiming and what you're saying really be reasonably vetted. And we really do believe that this applies to all levels of a corporate statement, not just a product label, but everywhere. And you really need to think before you speak. The practical outcome of that is really just understanding what to not say, a lot more than understanding what to say in a lot of ways. But it's important to recognize that pressures to make sustainability claims, even offhand and you know, in speeches and things like that, are also going to be very important. I think it also really starts going towards a lot of the environmental reports that companies are starting to publish. I believe they're going to get more and more scrutiny as the world continues to evolve on these items. The other thing that's also probably worth thinking about, and we talked about it at the beginning of this, is the reliance issues that come by you making these claims. Current guidance about greenhouse gas accounting and other items really sort of tend to say you can rely on public statements of others. And so it's not only this fraud question and the consumer action, but it's really everybody in the chain relying on your statement could potentially have a claim against you. So a theme from the last CLE and another theme in this CLE is, of course, be transparent and above all, be accurate. And Theresa noted that there is certainly some tension with respect to accuracy and transparency and real estate in order to be transparent and accurate. But certainly as you work through, for example, your sustainability reports, your ESG reports, you should have the real estate to be transparent and accurate. That's going to be important. I think the other piece is there's no shortcut in a slogan. And having sort of disclaimers attached to slogans wherever they may be is unfortunately likely to be necessary until there's some rationalization about the different meanings of different terms. Eventually, that will come through. What you can consider sustainable, what you can consider net zero, what you can consider carbon neutral. So those are really the things to really think about. Consistent with that, really don't overreach. You don't want to be making claims you can't quantify. You don't want to be making claims that says, close enough. One of my personal favorite issues I once saw in an ESG report was a firm that was involved in the business of helping sustainable projects for a fee. So they were essentially setting up sustainable projects for a fee. That was their business model. Well, their ESG report claimed all of the environmental benefits of all the projects they helped set up as part of their business. Is that true? Yes. Could you probably survive a claim today? Yes. Would you be able to survive a claim tomorrow? We don't know. But those are the things that it's really important to think about and work through as you're trying to implement internal best practices and as you're trying to assess risks, not only with respect to your external facing discussion, but also within your internal facing and supplier facing and supply chain discussions as well. And that really means you have to be thinking about who are your suppliers, who are you doing business with? Are you comfortable with the inputs? Do you know enough about who you're buying from in order to be comfortable making claims farther down the value chain? The current greenhouse gas guidance sort of turns that as the inverse. And what the current greenhouse gas guidance is telling us is if you push down requirements to your supply chain, you can take credit for the interventions and for the carbon reductions that you've created by forcing this supply chain to have to think about their products differently. But I believe that the inverse is also true, which is if you're going to be making net zero claims, your scope 3 inventory needs to be really quite accurate. And that if you're going to be relying on the reporting of your third-party suppliers, you should at least have made some kind of reasonable effort to figure out the veracity of their claims. This gets harder and harder as entities become smaller and smaller. It also gets harder and harder as entities become bigger and bigger, just due to the diversity of third parties you have to work with. And there's no set answer of, what appropriate diligence would be. But right now, you're just relying on their reporting, and that may or may not be sufficient. And your reporting is going to be relied on by third parties. And so that may or may not be sufficient. So how do you solve for that? Well, that becomes the next real material question. Using available and reputable third parties to certify your product label claims is unfortunately the best and highest standard at this point in time. And why do I say that that's unfortunate? Well, I think the first fundamental question is, who are these parties that are certifying you? They tend to be NGOs, they tend to be not-for-profits, they tend to be reputable to the best we can tell. But oftentimes they're not necessarily large enough to have a industry-wide reputation. There isn't sort of the underwriter's laboratory kind of standard for these kinds of items. There may be a pecuniary interest, much as the rating agencies getting paid to rate your debt, that could also be questioned by these certifications. That said, having a third-party set of requirements and having them certify you've met those requirements at least gives you something very significant to substantiate any claim you may make. And part of the question over time is going to be, well, I've now met these certifications requirements. Are those requirements sufficient? And we're not going to know. Right now, we don't know, but we continue to say, if you have requirements that you can put in front of people, you can probably survive claims today, and we'll see how that evolves. And so what does that ultimately mean? It means, like with all claims, scientific evidence is always going to be the gold standard. Where possible, set goals and standards based on demonstrable, replicable scientific evidence or metrics that can be backed by data and verified. That's great lawyer advice. But I will tell you, I think practically that's going to be very challenging, because the science itself on certainly carbon emissions, carbon inventory, sustainability, what is a sustainable fishery, what happens if you put other additives in your Manuka honey? Have you, are you doing something that requires the river to be dredged so that the Tupelo honey trees can't be growing? Nobody knows. Those scientific standards are still being discussed at the international level. They're still being discussed, quite frankly, as methodologies to measure these carbon outputs are developing. There are best practices, but there are concerns that a lot of these best practices are not usable or reasonable when it comes down to practically implementing them. So that doesn't really make them worthwhile. There's no legal standard against which to measure any kind of science-based standard. And so while scientific evidence is always going to be the gold standard, that's probably worthwhile for your actual direct emissions, your scope 1 claims. Yeah. But scope 3 becomes more and more challenging.
And I think there's an important footnote that we can add to the scientific evidence. It's not necessarily that you need the scientific evidence for the scope 3 claims, right? It's more that, can you have some replicable, reliable, verified data that backs a claim? So let's think back to the Myers versus Starbucks case, right? And Mars was let out because they could demonstrate, they could trace 24% of their inputs from the farm to the factory. So there was a percentage, and they could trace it through tracking and good data. It's not a scientific claim, right? It's not saying we're reducing our emissions by whatever, or we're having this impact. on sustainability. I'm making a specific claim about the inputs to my cocoa product, and that I can trace those inputs. I'm not telling you how much I can trace, but I can trace those inputs. And if you back it with reliable data, that is helpful. And for now, I think that's part of the stopgap on those scope 3 type claim, right? What is it that you can do internally within your organization to support the claim? Or what data can you get from your suppliers to help you demonstrate that claim? What do you demand of your suppliers in terms of data when they deliver a piece of that supply chain to you? That's also something that can be helpful in certifying and otherwise supporting the claim made on the product label.
And I think to go with that also is, what should you be claiming, right? The Mars was dismissed because their claim was directly related to, we can trace it to the farm. And for Mars, from a commercial perspective, that was a sufficient claim, and it met its needs, and it was substantiated. Whereas Starbucks is saying these are all sustainably sourced cocoa. And that's so broad. That's what Starbucks wanted to make that claim, but they also left themselves open to material liability.
So let's talk more then about the practicalities of. And I'm just going to speak to God in the room here. I can't advance the slide. Could you advance the slide, Rima, please? Thank you. So let's talk about what's some guidance that we can give you, right? How can we help you mitigate that risk, or at least understand the complexities of the risk and how vast it is? And the theme today, unfortunately, is we can't tell you what to say. We can only tell you what not to say. So why can't we be more affirmative and say, if you say this, you will be fine? And part of the reason is there's just no consensus. There is no current guidance that has been issued by the FTC or really any federal organization at the federal level that will tell you what is acceptable. And we're still making our way through that rulemaking process. And we thought we might have some new guidance, but the existing guidance is 30 years old and was last updated more than a decade ago. So I would say it's not reliable. And the claims that corporations want to make and that the market is demanding they make have totally switched and changed from what the existing guidance protects or tells you what would be safe. So we just don't have a federal standard. We don't know what it is, right? Specifically for sustainability and for any carbon type credits. What we can say is that in all of the recent wave of greenwashing cases, those cases that are backed by data, those cases that have a very tailored claim on the product label or a very tailored corporate claim as to its carbon neutrality or its carbon offset program, those cases get dismissed more frequently. So if you can be specific and use few words, that's the goal, right? We want to have a claim that is accurate, that's specific, and uses as few words as possible because you want it to fit on the label. You want it to be a tagline. You want it to be something that's memorable. And we understand that having asterisks and footnotes in your sustainability statements is not optimal, it's not preferred, but that may be what is required, at least until the guidance catches up with where we are in terms of corporate communications and disclosures around sustainability and carbon. So if you can get scientific evidence, that's the gold standard. If you can't have scientific evidence, have good, solid, demonstrable, replicable data, whatever it is, and use that as your guidepost. Also, if you're all in your own industries, whatever your industry standard is, if you can trot out that industry standard, and whoever your leading verification NGO or nonprofit or standards board is within your industry, that's also helpful too. We've seen recently that it's unhelpful in a very specific consumer context of sustainably caught fish, right? At least on the motion to dismiss stage. It very well may be that those industry standards and that certification wins the day on a motion for summary judgment or later on at a motion for class certification. It's quite possible that that industry standard does prevail, but it doesn't help at the initial pleading stage or the initial outlay of cash in defending against that lawsuit. But the more certifications you have, the more industry standards you can demonstrate that you meet through your own good data, also helpful. So we can't tell you exactly what to put on your label, but we can tell you with a little bit more specificity what not to say. So Zev, I'm going to start just by asking you, what are some of the claims that you have seen or advised clients to absolutely avoid making?
Well, I mean, I think you've raised the big one. We're sustainable. We're a sustainability company. We're in the business of sustainability. That's really the big one, because there's no actual good definition of the word sustainable. In fact, when we talk about sustainability, just you and I, well, what exactly are we getting at? How broad is that? And so it becomes a real challenge from that perspective. I think the advice that we give to clients often is to say, why do you want to say that? To whom are you making that statement? And what's backing it up? And, the why really is a big part of that. But what we're seeing is the why is now, it's a commercial necessity for us to demonstrate to the marketplace that we have a sustainable product. And we're looking at products that are disparate, B2B as well as B2C. And so it's an important thing to think about, that as B2B continues to evolve, those kinds of claims are going to be relied on from a packaging, from your PowerPoint decks and things like that. We tend to, or at least I tend to say, well, do you have a third-party verification? What we're seeing is entities that are reasonably sophisticated, but this is non-core, oftentimes look to a third-party verification company to say, you're certified as carbon neutral under our standards. We've identified carbon projects for which you're buying the carbon credits, or which you can take credit for the interventions occurring under our standards and existing guidance. And we've also worked with you to ensure that you're buying 100% renewable electricity and offsetting any scope 2 emissions. And so there you go. Your scope 1 and scope 3 are offset, your scope 2 are offset, and this third party says you've done that. If you are more sophisticated entities can start to do that themselves. I mean, the Googles of the world have been carbon neutral since 2007, and they have a lot of expertise in-house that allows them to go manage that. And so part of that is also to say, why do you think you can make that claim? And we really don't know the answer, but what we do see a lot of is entities saying, gosh, the market is pushing me to be a quote unquote sustainability company, and let's come up with 6 things that we sort of do. Remember, this is not just about carbon on the sustainability side. If you manufacture something, you can show reductions in water usage because you've made capital investments. Well, yeah, that's really helpful. The question is will that be sufficient for you to say we're increasing our sustainability? My point of view is, from a cautious perspective, likely not, but we're going to see more and more companies push the limit on this. And I really think we're going to get enough of a body of judge-made law sooner rather than later to know what's going on. I don't have a lot of confidence that the FCC is going to update the green guides, that we're going to get a lot of at least federal guidance on this. I do think some states or state attorney generals will help push forward the state of the law. But at the end of the day, I still think the FTC fraud standard, product labeling standards, general representations and warranties and contract law are going to help bring us forward from a legal perspective. That's the standard against which you're measured. And I do want to say that as these things also evolve and as these risks continue, one of the things other people should be, or most people should be thinking about is, what does that mean for market and contracting? Because there's going to be a lot of third-party reliance. What kind of indemnities, and are they worth the paper they're written on from a third-party certification entity, do you want to take? What is the credit risk you're taking by relying on certain suppliers? Those are going to matter more and more until the law is sufficiently flushed out that you can really assess not only the risk of suit, but the economic risk that comes from that suit.
And I think it is important to remember, while it's troubling and hard to get out on a motion to dismiss, the reasonable consumer standard can be your best friend, right? Because what is it you should avoid saying? You should avoid saying something amorphous that nobody knows what it means. We're sustainable, we're eco-friendly, we're ethically sourced. Well, nobody knows what that means. But if you say, we have reduced our carbon emissions by X%, well, that's demonstrable, that is clear. And the courts, the judge-made law that exists so far is actually going to be helpful to you, because as we saw in the Ninth Circuit case from Trader Joe's on the honey, and as we saw in the Eighth Circuit case about the pet foods, what a reasonable consumer is going to take from that is not that, oh, somehow you have stopped using greenhouse gases at all, right? No, what a reasonable consumer is going to take from that is in the context of all of the other public discourse that exists on how companies are reducing their carbon footprint, right? So that reasonableness can help. It's not to say, we'll never cut down another cocoa tree in sourcing our hot chocolate. No, that's not a reasonable interpretation of the label. And it can actually be helpful going forward. But the more specific you can make your claim, the better off you are. The more general you leave it, the more subject to risk and the higher that risk is going forward, especially for litigation.
No, I think that's right. Which brings us to the last bit of the presentation, which is, thank you for attending. We've really enjoyed everybody who's joined us virtually. Again, here's some more information. If you need credit, because everybody wants to get their credit, remember in Minnesota, June 30th is the reporting deadline. I guess that's all we got.
Thank you very much.
Thank you.